I'm Drew Stevenson, and this is a lecture about federal regulatory preemption of state law. We're going to talk about express, implied, and partial preemption, and also something called a saving clause. And this lecture is actually for two of my classes, for my administrative law class and my statutory interpretation and regulation class, because we talk about it in both classes. From an administrative law standpoint, this usually comes up with the question of, does a federal regulation preempt state law? And that could be a state statute, a state regulation, or even a state tort law, like a personal injury law and the law of negligence or findings of negligence in a state court. A lot of the cases that make their way into administrative law casebooks are precisely about that last point of federal safety specs preempting or canceling out judicial redress for under personal injury law in state courts. On the other hand, we can, there's a question about whether we're talking about a federal law, statute, a federal regulation, or maybe sort of the federal common law. Although, as I'm sure you understand, that under the Erie doctrine that you learned about in your first year class, we aren't supposed to have federal common law preempt state law. So that's that issue. The interpretive issue, and if even in administrative law, the opinions are a lot of statutory interpretation, is trying to interpret these very confusing preemption clauses in statutes and sort them out and figure out exactly how drastic or permissive Congress intended them to be, because these can really have a lot of consequences. So let's dive in here. And this is supposed to be kind of a quick general explainer of this area that instead of focusing on one case, but it will help you understand the cases in your casebook. So let's start with express preemption. Express preemption occurs when Congress expressly preempts state law by stating clearly in a statute that it intends for its enactment to preempt state law. So we usually get a whole clause or subsection of a statute that's the preemption, the express preemption clause. And in the case that's for my administrative law class, that's Alexis Geyer versus American Honda, we have an express preemption clause that the court then interprets rather narrowly or cancels out with another section of the statute. Please note that these express preemption clauses can be partial preemption. Partial preemption occurs when provisions of a statute preempt certain aspects of state law while preserving other aspects of state law. Okay, what is a saving clause? And by the way, I apologize if sometimes I slip and call it savings. The Supreme Court has alternated back and forth between calling it a savings clause and a saving clause, but it seems like the singular has won out in recent years and they're being more consistent about it. So a saving clause is a provision in a statute explicitly providing that a certain parallel remedies, whether state or federal, survive the enactment of the new federal statute. Please note, sometimes we have a saving clause that basically is saving the statute in case we use the phrase for a severance clause in the statute that says if part of the statute is unconstitutional, that the rest should still survive or hang on. But normally in preemption cases, when we talk about a saving clause, the saving clause is almost doing the exact opposite work of an express preemption clause. It's saving the other aspects of state law that aren't canceled out or preempted by the preemption clause. So preemption may still occur even if you have a saving clause. Even in the presence of a saving clause, if the state law claim would frustrate Congress's purposes or cause some sort of in practice conflict with federal law. All right, let's talk about implied preemption. And this it actually is the harder part, I think, as a student, although I think the cases about express preemption are harder to read because the courts have such convoluted ways of interpreting or trying to get around express preemption clauses. So implied preemption occurs when a court implies or infers congressional intent to preempt from the circumstances, even when there's no express preemption provision in the statute. And so there's really three types of implied preemption. The courts don't always identify them, but this is more of like for the classroom thinking about what type of preemption are we talking about. And the first is field preemption, and then conflict preemption, and then obstacle preemption, and I'm going to explain each of these. So field preemption is the idea, all of these are types of implied preemption, and the idea is that even though a federal statute does not expressly preempt state law, federal law may be so comprehensive in an area that courts conclude Congress must have intended to displace state law within that whole field occupied by Congress. And one area of this, some of our national pollution laws like the Clean Water Act or Clean Air Act, there's an argument to be made that maybe Congress has just occupied the field. They've regulated this so comprehensively from every different angle that there's really no room left for states to step in and add their own kind of idiosyncratic state laws to it. So this is field preemption. By the way, of the types that we're talking about, this is the most rare of the three, where we're going to say this, we're just going to infer without any express indication from Congress that Congress must have meant to occupy the field, so to speak, from a regulatory standpoint. Conflict preemption is more common. Conflict preemption occurs when a state law is in actual conflict with a federal law. And what do we mean here? We're saying that this is where obeying the federal law as an individual might put you in violation of the state law, or complying with the state law puts you in violation of the federal law. That would be one type of conflict preemption for let's say, the regulated industry or individuals. But it could also be courts, right? Where courts, if they're applying one, they're mutually exclusive for the court when they're adjudicating cases. So you should think of conflict preemption as mutually exclusive cases, even though Congress didn't say we preempt. It's presumed that Congress intended state law to be preempted when they do this. And so, for example, if federal law mandates a course of conduct that state law forbids, that state law is preempted. But we could also get a conflict preemption case where, again, for a court where federal law would produce one result in a case and state law would require the exact opposite result, like the other party win the case. And that could be also a kind of conflict preemption because the two consistently produce mutually exclusive results. Okay, and our third type is obstacle preemption. And obstacle preemption is when a state law poses an obstacle to the accomplishment of Congress's purpose in enacting the federal law. And so in other words, there's some sort of friction, or what the state is trying to do makes one example would be more difficult for the federal government to monitor or to enforce its regulations. Or the federal government had a particular goal that is indirectly being thwarted by a state law. And now this, I hope you can see, is more murky. So there's more to argue about here, because you might not even have a law that's on the same purpose, same topic as the federal law, but ends up kind of creating interference between the state government and the federal government on some point. And that would end up creating a sort of obstacle preemption. Okay, that concludes our quick explainer of federal regulatory preemption of state law and the idea of a saving clause.